All right. Next, please.
Trevor Copeland, I'm a patent attorney in Chicago. The panelists have talked some about the difficulties with availability and particularly easy availability of information with respect to the patent notice function, specifically in the business method and software patent field that seems to have been exploited by some parties. And I'm curious what the panel's thought is as to whether or not non-practicing entities, so-called patent trolls, have exacerbated this gap between software patents and, say, the biopharmaceutical and mechanical arts. If so, then since we still have a good soft spot in our heart for small inventors, is there a way to differentiate between, the geek that came up with some great program in his garage versus somebody who has developed sort of a corporate-style patent thicket like a Ronald Katz?
Okay, look, first of all, with respect to the patent stuff, one of the rules that I hope everyone would agree to change is to adopt the first to file rule as opposed to the incredibly crazy rules that we have now about progressive development towards a patent, which is supposed to give the protection to the small guy, but essentially create sufficient uncertainty that the IBMs of this world can bully people into submission. So that's one thing I think that you would want to do with this. Secondly, it's interesting about the particular troll problem is that was the constant under-theme with respect to the situation in the eBay case, when as best one can tell, there was no troll that was around. And what I think what one wants to do about these circumstances is to say, if you think there is a serious troll problem, you control that by estoppel and by laches. You don't control this particular problem by changing the entire rules with respect to injunctive relief. I quite agree with Daniel, is everybody would prefer to have money than to having an injunction. But the whole argument is if you get the injunction, you could get more money than you can if you get an action for damages, and that's why the difficulties, of course, are there. And the point about this is the same as in the encroachment cases. If somebody knows that the injunction is credible, they will come for a license. If they think it's not credible, they will take their chances. And so when Mark Lumley, for example, says that nobody should get an injunction when you issue non-exclusive licenses, which is something he suggested, that's just an open invitation for all sorts of game playing, because the troll issue is just one of many permutations on that stuff. And generally speaking, when you have non-cooperative behavior, the scoundrel is always on both sides of the transaction. It's not as though it's always the patent guy is the bad guy. There are many opportunists on the other side as well.
Let me, the patent notice, the fuzzy boundaries problem, I agree is a very important one and a critical one, but I don't think patent applicants are at all to blame. I think the Federal Circuit has moved the ball on what the law is regarding claim construction so many times with Texas Digital and then Phillips, and who knows if we're even going to get Markman overturned and it's going to go back to a jury at some point. The burden of proof for invalidity. I always propose that patents should be construed as they are as application, which is the broadest reasonable construction, because that's the notice function. A reasonable actor is going to read the patent and say, well, it could be construed this way, that way, or this third way. The broadest reasonable way is this third way, and so I'm going to pretend the worst case scenario, and I think that would deal with it. But I don't blame, some people say, well, patent applicants intentionally write ambiguous words in their patents. I don't think that's the case. I think it's the Federal Circuit changing how claims are interpreted that's actually caused so much of this commotion and confusion about what is a patent covering or not.
Let me chime in with a couple of comments. Go back and think about rent-seeking through litigation. What do you want to do? You want to make it easy for defendants to get out of the courtroom without paying very much money. So one thing we should do is what the Federal Circuit did in the Festo case, make it easy at a summary judgment stage to say non-infringement, no infringement. So anytime we can craft a rule that makes it easy for defendants to get away from a vexatious claim, that's desirable. Fee shifting is obviously another way that we can do that. First to file, I think, is a good idea. So think about it as a problem of vexatious litigation, and the standard tools that are applied should be applied here. I also want to emphasize, though, that your question about what's different about pharma versus software, the cost of entry into the business of being a patent troll is much lower in software than it is in pharma. So that it's not a good business model to ask some lawyers in Connecticut to write patent applications and see if we can get them to issue through a biotech examiner. You're not going to have any success doing that. But my research and the graphs I put up ended in 1999 before trolls were really a big deal. The trolls in my data set are Texas Instruments, IBM, Lucent. British Telecom. British Telecom gets a patent on some kind of routine telecom invention and then asserts it against the internet. That was the real problem. It's not just non-practicing entities, it's anybody who, sensibly enough, because they want to make some money from a patent that they're not using for anything in particular, is going to go out and assert it against strangers. So it doesn't matter if they're non-practicing entities, it doesn't matter if they're small or big. It's a game that everyone can play in a world where patent boundaries are way too fuzzy.
Do you want to comment, Scott?
Why don't we wait and I'll take
Okay. Next, sir.
Thanks, sir.
We can't hear you. Loud.
D.A. Duggar. I'm an IP attorney with Kenobi Martins. My question first to Professor Meurer and then to the panel in general. You mentioned that there should be greater deference to the PTO. Isn't that in essence what happens in the Eastern District of Texas, where it is a plaintiff's forum and the patents are often valid and infringed? And then to the panel in general, you mentioned greater deference to the trial courts. Does the panel think that a solution is specialized trial courts, much like we have a specialized appeals court?
That's a great question, and I think you got me.
Yeah.
So let me back up and say, I hope I was clear, but I might not have been. So it's very interesting. Deference with regard to 102 and 103 is a big problem, and the KSR case talked about maybe reducing the deference.
No, it
or the
increased it.
presumption. Sorry?
It increased it.
Right. Well, but the footnote that's in play now in the Lucent v. Microsoft appeal is whether or not we need a strong presumption of validity. And no, I don't think we should have a strong presumption of validity. So if that was the gist of your question, I agree completely. Yeah. What I want is deference with regard to claim construction. I'd like to see all of the prosecution history recorded, and I'd like to see courts use it, and I'd like to see patent examiners get more active in terms of eliciting claim construction from applicants. Or if they can't get it from the applicants, give their own construction. Here's what I thought this term meant. That's why I decided to issue this claim over this prior art. So I'd like that to be produced, and I'd like courts to defer to it.
Just one comment on this. I don't know about Marshall, Texas, but I do know about Madison County, Illinois. And I think that once you start getting these patent sinkholes or these tort trial lawyer sinkholes, the thing to do is to basically strip them of their powers. I mean, one of the great achievements of the Class Action Fairness Act was not its elegance, which is not, but it really did get removal into federal courts. And I think what you have to do is find a way to get places out of districts that simply are outsized with respect to their performance. And, you know, that's a straight problem of judicial administration, and it stems from the fact that if plaintiffs are given the option as to where to file in a national system, we know where they're going to go, and we know that they're going to go there for all the wrong reasons. So, I mean, I think that. In terms of deference, I mean, I think the more you have something look like a rule, the better you're going to be, but it's extremely difficult. Just one illustration. You can have no difference, right, and have no, for example, doctrine of equivalence, and that would solve one problem on literalism. But at the same time, what it will do is it will encourage people to make trivial substitutions outside the literal framework of a patent, and so you're losing the outsider control. The reason this problem is so hard is every time you do something nice to one guy, you're doing bad to somebody else, and you're trying to minimize two sums of abuse simultaneously. You're never going to find the optimum. What you have to do is to kill the obvious outliers and then try to have rules with fewer degrees of discretion, and the Supreme Court has gone the wrong way. They were just dead wrong, in my judgment, on KSR, and it actually mattered a lot more than they did it. I mean, if you have recognized evidence instead of anything you want to introduce, what KSR did is it opened up the universe to all sorts of dubious scoundrels in testimony. That's not an achievement. That essentially goes against what Michael said. Michael's system on definite property rights, which we agree with, is consistent with the basic kind of framework. And his issue is if you can do it, and if you can't abandon it, may not be such a terrible